Welcome back to Just Liberty, where liberty and justice meet. I'm Alan Reinach, president of the Church State Council, here with my co host, Bettina Krause, editor of Liberty Magazine, the oldest and very best magazine devoted to religious freedom. And together we are trying to take back liberty from the political extremes. Today we have a very interesting topic about how kids in the foster care system are often the victims of culture war battles because of conflicts over beliefs about sexuality and LGBT uh, rights sorts of things. So, with no further ado, Bettina, why don't you go ahead and introduce our guest?
We are delighted to have with us this morning Lance Kinzer, who is Director of Policy and Government Relations at the advocacy organization First Amendment Partnership. Now, that is a Washington-based organization, but Lance actually came to his current role by way of Kansas, where he
Correct.
practiced law for a couple of decades, went on to serve for 10 years as a Kansas state legislator. And one of the many pieces of legislation he authored was notably the 2013 Kansas Religious Freedom Restoration Act. So, Lance, welcome to the podcast.
Yeah, thanks so much. Great to be here this morning.
So, we're discussing a topic today that really has been in the headlines a lot recently: gender dysphoria. Um, so, why don't you start, Lance, by sort of painting some general background? What is gender dysphoria, and why has this issue become so divisive within the adoption and foster care space in recent years?
Sure. Well, I'm certainly not an expert on gender dysphoria, but the whole issue of sexual orientation and gender identity as it relates to adoption and foster care has been an issue that has been of concern at the national level, but certainly at the state level for well over a decade. And it arises in a couple of different contexts. Initially, there were efforts, some at the federal level, some in various states, to preclude faith-based adoption and foster care agencies from being able to contract with the state, which in many places has been the norm for years and years, to assist with adoption foster care placements. Uh, there's been efforts to restrict that based upon the fact that some groups, because of their sincerely held religious beliefs, only want to place, say, married mothers and fathers, for example. And we've been at First Amendment Partnership involved in helping states that want to protect their relationships with faith-based agencies pass legislation, going all the way back to kind of the early teens with a bill that passed in Michigan. But there are, I'd say, about a dozen states now that have adopted really good protections in state statute. There's been some favorable litigation in that area as well. People might be familiar with the Fulton v. Philadelphia case from a few years back. That case was narrowly decided in favor of Catholic Charities in Philadelphia in terms of their ability to continue to contract with the city of Philadelphia. That's kind of how their system works there to provide foster and adoptive services. And that was actually a unanimous U.S. Supreme Court opinion, but a narrow opinion. But even though it was a narrowly drafted opinion, the impact of that, I think, has been quite favorable in terms of just other litigation. For example, there were a couple cases in South Carolina that had been pending. They don't have a state statute there, but they do have a strong executive order protecting agencies. And there was some argument that there were both due process and establishment clause problems with contracting with agencies that wanted to place consistent with their sincerely held religious beliefs. Those cases both resolved favorably, essentially kind of saying the establishment clause and the due process clause can't require what the free exercise clause prohibits in terms of limitations on those agencies. So um, that issue is not fully resolved by any stretch of the imagination. And in fact, we still encourage states to pass their own protections. A couple of states have done that even this year for agencies. But what's happened in the last couple of years, and it's more than the last couple of years, over the last 5 or 6 years, is that a analogous issue has emerged where states have been restricting the ability of people of faith who are deemed by the state to be insufficiently affirming of kind of LGBT identity of a child, precluding them from fostering, adopting at all. And what I want to stress here is that these states like Washington and Oregon and Massachusetts, and there was a case in New Jersey, there's some cases in Vermont. Um, these states aren't saying, hey, as we're making an individualized placement decision, it may be that certain people based upon their views on these issues aren't an ideal placement for like a 15-year-old gender dysphoric kid. What they're saying is that if we deem you to be in the abstract insufficiently affirming, you're not eligible to foster or adopt at all. And that's really radical. Uh, and it makes little to no sense when we consider just what the stats say about the willingness, the kind of heightened willingness of people of faith to engage in foster and adopting. For many states, that policy taken to its logical conclusion would just be absolutely devastating with respect to the population of people eligible to foster or adopt. So, to end this very long answer to a short question, I'll just say that we're working beginning a couple of years back. We've been working in a number of states, both to continue to encourage protections for faith based agencies, but now more recently to encourage states to pass clear statutory protections for people of faith around eligibility to foster and adopt. And be happy to talk about kind of some of what's happening around the country there, how the bills are structured, whatever would be of interest to you guys and your listeners.
Well, Lance, I feel a need to take us back to one of the foundations you were laying in this conversation, because I'm afraid you may have lost some of our listeners, because the context of the Supreme Court's decision in the Fulton case has really been a kind of hostility against free exercise that's been part of First Amendment doctrine since 1990. So most of yours and my professional lives, uh, we've faced an uphill battle when it comes to protecting free exercise. And that's really the reason why the case was decided so very narrowly and basically said, look, if you as a municipality, if you have discretion, then you have to you don't have the kind of generic facially neutral system that applies the same standards to everybody, and you can't exercise that discretion in a way that discriminates against religion.
Yeah.
But and that was the narrow focus. uh but
Right.
we're still in, until the Supreme Court wrestles with that doctrine, we're still in a fairly hostile constitutional climate, aren't we?
Yeah, so going back all the way back to 1990 to set the stage, a lot of folks aren't aware of the fact that for a significant range of laws that don't directly target religion, the standard of review that courts apply to determine whether there's a free exercise violation is actually very low, just a rational basis standard. And candidly, the government almost always wins, not always, but almost always wins under a rational basis test. Traditionally, free exercise cases, like most cases in the free speech lane, for example, were decided under strict scrutiny. And to get a little bit more complex, in the aftermath of that problematic US Supreme Court opinion that established this lower standard of proof with respect to a significant number, a significant category of religious liberty cases, Congress acted to ameliorate that at the federal level via the Religious Freedom Restoration Act that passed in 1993. It remains in effect, but because of a subsequent US Supreme Court opinion in the late 90s, that standard, that strict scrutiny standard, only applies to federal law unless your particular state has taken action And that goes back to in the introduction talking about Kansas passing a Religious Freedom Restoration Act in 2013. We're now at 30 states that have passed some version of a Religious Freedom Restoration Act, and that's maybe something for a separate podcast sometime. A lot of really good news. 9 states post-COVID have passed their own Religious Freedom Restoration Acts, and we've been involved in almost all of those. But yes, the reality is that in most instances, when we're talking about restrictions on foster or adoptive parents, we're talking about either state or local laws. And if those laws are facially neutral, generally applicable, and you don't have a state RFRA, you may only get rational basis review. And so, what we've seen in the litigation is, um, initially parents were doing quite well. I mean, it's terrible that they have to litigate on this question at all. And, for example, there was a Third Circuit Court of Appeals case that was decided in 2022, LASCHEV, New Jersey Division of Child Protective Services. And in that case, ultimately, the parents were able to prevail, and in terms of their right to participate in the foster system in New Jersey, but it basically took 2 years of litigation to get to that result. Similarly, there was a case that many of your listeners may be eh, aware of, a case involving a Seventh-day Adventist couple, Blaise v. Hunter, which was decided in Washington in 2021. That took a couple years to resolve as well. But more recently, um, we've had some troubling results. So, for example, in Oregon, there's a case called Bates that's up at the Ninth Circuit right now, where a woman lost at the federal district court level. Basically, she was told she wasn't eligible because, in hypothetically, not with respect to the placement of any individual child who actually was indicating, a desire to be called by different pronouns, to engage, to be taken to, gay pride events, things like that. They were said, hey, if you're this toddler who you're thinking about, a foster care, giving foster care to or adopting, if 10 years from now they were to say, hey, I'd like you to use different pronouns, or I'd like you to start taking me to, gay pride events, would you be supportive of that? And this mother was like, well, that's quite a hypothetical, but, here are my religious beliefs. And I would, of course, love and support this child like I would my own, but I would do so consistently with my religious beliefs. And there was a federal district court judge in Oregon who said, okay, the state of Oregon can preclude you from adopting or fostering any child in Oregon because you hold those views. And that case was argued last summer at the Ninth Circuit. So we're hopeful we're going to get a little more clarity. And maybe we ultimately will get a clear U.S. Supreme Court decision on this. But in the meantime, we think it's really wise and prudent, and I can talk a little bit more about why, but really wise and prudent, even for states that don't have regs or policies or statutes that allow this thing to kind of happen, to pass clear, kind of contrary protective legislation, and to do it as soon as possible.
So let's dig into that protective legislation
Yeah.
that you are advocating for. I mean, because the patchy results that you're getting in the
Hmm.
courts makes that approach even more important.
Yeah.
Um, I'm guessing that most of your legislative success is taking place in red states, right?
Sure.
And
And
yet,
so,
the problem
yeah,
would be mainly in blue states.
Yeah, the problem in terms of there actually being policies, regs, or statutes is more of a blue state issue. But the problem actually goes beyond that. So what we've found in almost every state where we've proposed legislation is that people step forward and indicate, hey, I was told during the home study process I probably wasn't a good fit to foster or adopt in Iowa, in Kansas. Those are 2 examples where, there is no policy, allowing the state to restrict people from fostering or adopting based upon their sincerely held religious beliefs, and yet, in public testimony before the legislature, we had families, multiple families, step forward to talk about their experience. Now, sometimes this arises in what I would say kind of a soft sort of way, where there's a lot of education about how do you appropriately foster, a kid who's LGBT, and a lot of just basically parents are made to feel like if you're not fully on board with these educational materials, you're really kind of an outsider. And sometimes, even though that people could have made it through the whole process, they just kind of self-select out because they're made to feel as if maybe I'm not supposed to be here. And that's really problematic. So one thing that having a strong state statute does, and we interact with a lot of faith-based groups that help people through the process of going through their home study. These groups are very supportive of this kind of legislation because I said it's very useful for us on the front end to be able to say, look, there are going to be certain kinds of educational materials that you're going to be exposed to, certain sort of conversations that happen in the home study process, but you have clear protection in statute in our state to foster and adopt consistently with your sincerely held religious beliefs. But in other instances, even in red states, it goes a step further where individual caseworkers who are involved in the approval process will just tell people, "Hey, we don't think you're a good fit to foster." And it's usually done in that way because they know they don't have a legal leg to stand on in their state to say it. But the person who's going through the process typically doesn't know what their legal rights are, isn't aware of what the standards are. And if they're being told by the representative of the state or the agency they're contracted with, "Hey, we've decided you're a bad fit," most people, unfortunately, don't, well, it's understandable that they don't want to litigate it. They don't want to, fight about it. They just step back. But of course, that's terrible from a religious liberty standpoint, but it's also terrible for kids in most states. There's a lack of foster care capacity. We need more people in the system. And so having fully qualified people being told, you're not welcome here because of your religious beliefs is bad as a matter of religious liberty, but it's also terrible for foster kids who aren't going to be able to be placed and ultimately adopted out of foster by these families.
It strikes me, Lance, that these kids are a victim of the culture wars.
Yeah,
That,
absolutely.
it's very easy to go surfing, YouTube or wherever, and finding intemperate uh, religious voices, saying things like gays should be lined up and shot in the back of the head, that sort of thing. And, you get this, kind of violence and hostility from one side, and it generates on the other side. On both sides, you have those who are really kind of battling it out. And, I mean, I have lots of contacts within the LGBT community who are perfectly happy to live and let live, and to respect
Yeah.
people of faith and to be respected. And, we all live in the same place. Now,
Yeah.
uh, so we've got this kind of culture war dynamic, which produces a lot of injustice. And then you have innocent children who just need a loving family to foster or to adopt, and
Yeah.
and they become victims of this.
Yeah, I agree. I mean, I think the bottom line principle is that states should be encouraging as many qualified people as possible to foster and adopt, and imposing ideological litmus tests, as some states are doing. It's unjust to the prospective adoptive or foster parents. It needlessly limits the pool of available families, and it's exactly the opposite of what kids in the foster system need. And so we do find um, we've gotten, a limited amount of bipartisan support in some states on this. In some states, the opposition has been more tepid on this issue than it has been, for example, on the agency issue. But I will say, unfortunately, in most states, this issue still has had kind of a partisan overlay to it. In Kansas, for example, this year, a bill just recently passed a few weeks ago, but it did so over the veto of the Democratic governor in in Kansas, and that was unfortunate. I think there's really no reason, for all the reasons we've discussed, why this should be a partisan issue. Just to be clear, the way the bills that we advocate for are structured, they basically do three things. They, number one, make it clear that no one can be who's otherwise qualified can be excluded from being licensed, having the just general approval to foster or adopt based upon the fact that they, in many instances, this is the way it arises, that they won't affirm kind of a list of ideological statements that the state has adopted around LGBT issues, that they can't be excluded based upon their basically their sincerely held religious beliefs, even if it doesn't interact with some sort of affirmative requirement to affirm a statement. Um, and that they can't be shadow banned in essence, where you don't say, okay, well, we'll allow you to be licensed, but we'll never consider you for any individual placement. So it kind of, on the protective side, it does those things. But then it also says, with respect to any individual placement, the best interest of the child standard, which generally speaking is established in statute in most states, um, continues to be controlling, and it's based upon a totality of the circumstances test. So you can take into account the religious beliefs or beliefs around these issues of the child or the family's child of origin in comparison to the views of the prospective adoptive and foster parents. You can weigh that and consider it just like you would any other factor. But it doesn't create a presumption that um, just because you hold these views, and we're very careful about this, we want those to be factors to be considered, but we also don't want to create the impression that, hey, it's just always the case that it would never make sense to put someone who is experiencing, a 13-year-old girl who's experiencing mild gender dysphoria, we should just have a policy. She's never placed in a family that has traditional views on marriage, family, and sexuality. And we're worried about that kind of precedent because, candidly, what we're starting to see is that that kind of standard is being applied in custody cases, but also in, for example, child in need of care cases. And so we recognize that every situation has to be looked at on its individual facts. But adopting in law a principle that says that you're just inherently not qualified to parent, that it's never in the best interest of the child for someone who is experiencing any level of gender dysphoria to be in the home with parents who aren't fully affirming. That's problematic in this adoption and foster context, but in a sense, it's terrifying in certain other contexts, and we're already starting to see some of those cases emerge. So this, I really do think, and I'll just stop this answer here, but your point about the idea that this is an issue that really, I'm hopeful that over time we're going to be able to find consensus. And I will say, in a number of states, we've had folks reach across the aisle or advocacy groups at least say, hey, we're not going to really fight hard on this one because we do think some of these states have gone too far in their policies. And we think this legislation strikes a good balance. We'd love to see more people across the ideological spectrum adopt that point of view, but we are seeing, some encouraging signs in that regard.
What a novel idea, bipartisanship, and a live and let live approach. I mean, what I love about what you are describing and about your advocacy effort is that, you know, we can have protections for LGBT folk and for children who identify that way, as well as protections for foster parents or
Right.
adoptive parents with traditional religious views about human sexuality. It is often, I was looking at some of the media around some of the passage of
Mhm.
bill in Kansas, for instance, and a lot of it was painted as an either or. You
Yeah.
either protect LGBT kids or you allow religious bigots to run amok. Um, and there's no sort of accounting for this middle ground which you're trying to forge.
Yeah.
We're running out of time. Let me ask you this. What does the future look like for this issue from your perspective? I mean, you're
Yeah.
working on the ground in a number of states. What do you see happening in the years ahead?
Well, I think until we have absolute clarity from the courts, I think you're going to continue to see um, in red states state legislative action to establish clear protective standards. Um, my sense is that while that lack of clarity exists, unfortunately, we're going to continue to see blue states formally, and then within the bureaucracy in red states informally, there continuing to be challenges for people of faith in this area. So my hope is that we'll get a good decision out of the Ninth Circuit soon, and that will be helpful. But legislatively, until there's real clarity, and sometimes even where there is a clear court case, just having clear statutory language on the books in your state is still helpful and wise. But actually, today, the Oklahoma House has a bill, a protective bill on the floor that we believe is going to pass. And there's still one that is, we hope, is going to be on the floor in Iowa later this week. And so the legislative activity continues right up to the end in state legislative sessions. And I think until we have a U.S. Supreme Court opinion definitively deciding this case, we're going to continue to see legislative activity in both directions in states across the country.
So, for context here, I really want to know how foster care systems do placements with respect to religion. For example, are there concerns about placing a Muslim kid in a Christian home, or a Jewish kid, or a Catholic kid in a Protestant home? I mean, how does, because this is not the only sort of values based ideological conflict that we have that's
So many,
deeply seated.
yeah. There are many states that have specific statutory provisions around religion and foster care, and typically, those provisions will provide a preference for placing a child in a home that aligns with the religious affiliation of the family of origin or the child, kind of depending upon age. And even in states where there isn't a specific statute on that, what I've tended to see is that's usually the way that works. Of course, the reality is um,
Mm.
that especially for some, for minority religions that have a smaller number of people affiliated, finding that match can be difficult. And so then they're typically looking for someone who will be supportive and who will help facilitate the ability of the child to continue to practice, in their faith if there's a desire on the part of the parents or the child to do so, even if there isn't an exact match. But of course, ultimately, um, they're not going to hold kids out of the system just indefinitely if there are otherwise qualified parents. But yes, the reality is things analogous to the issue that we've been talking about are not unique. And I think generally speaking, most states have tried to develop common sense solutions to those sorts of issues. And what we're really, trying to achieve is a common sense solution in this space of what do you do around issues of LGBT kids. But I think the thing to stress is
Mm.
that these parents
Mm.
are being excluded, completely in the abstract, totally outside the context of the
Yeah.
needs of any particular child. And so they're being excluded before you even get to the possibility of making a determination. Hey, might you be a good placement or a bad placement for this particular kid? In these states, you never get to that question because they're just being excluded entirely. And I think, candidly, it's an easy argument that makes no sense.
Common sense solutions. That's what we're all after. Thank you so much, Lance,
Yeah.
for shedding some light on this really challenging area.
Thanks for having me.
And all the best for your efforts going forward.
Yeah, thanks so much. Great to talk to you guys this morning.
So, Ellen, throughout that interview, I kept thinking this whole phrase of the best interests of the child. I
Mhm.
mean, that is such a subjective measure. I mean, how do you it it depends entirely on the priors you bring to that regarding
Right.
how that comes out.
That's been the standard in family law, for a very long time. I've done enough family
Right.
law to be dangerous. I try not to. Um, but yeah, it's really tough. And if you have, social workers tend to be by training and education are often much more progressive than the social and cultural norm, even in blue states, regardless of where they are. I was not at all surprised to hear that states like Iowa and Kansas which are fairly conservative overall, um, would have the same problem with social workers in the foster care system being having far more LGBT friendly and progressive values than, you know, maybe represents the mainstream.
Yeah, I guess it really represents the truth that we need to learn to frame issues not as either or, not as my way or the highway, but really try to come together and find ways to work through these really challenging cultural issues. Yeah, I mean, I'm glad someone like Lance is working in this space. I think he brings that approach to what he's doing, but I fear that in the main, society really hasn't come to that point where we're prepared to say, I believe I'm right, but I'm also prepared to work with you to find a solution, a practical solution to this.
And there's another problem we didn't get to address in our interview, which is how advocates are stereotyped and ostracized. So
Huh.
if you are a white male Christian advocating for religious liberty, you're put in a box. You're put in the right wing extremist box. And it's very hard to get out of that.
You almost sound like you're talking from experience there, Alan.
That's very astute, Bettina. Um, but it's why, our legislative successes, especially in a blue state like California, have been when we're able to partner with people whose progressive bona fides are obvious.
Right, right. Well, that's a topic also for another day, but we hope you'll join us again for another conversation about another challenging topic related to the religious liberty. And remember, until next time, eternal vigilance is the price of liberty.